this is it.
I'm very quiet. I got to the courthouse this morning. I'm like, is it always this empty?
That's a topic of our discussion for another day. Are you expecting another person?
Yeah. Right.
Morning, Ron McLean. Good to meet you. Had 5 listed, only 3 of them. What's that? Yes. Yeah. Give me a harder time than you.
I think given her time, body, our judges.
Yes. I was in, my last was at the 11th Circuit, so.
And then it was
But hey, how are you? I'm all right. No pressure at all. Clients watching on a live stream. It's a very, very basic issue at the end of the day. Just hearing unequivocal. One DCA said it is, one other said it's not.
That's the way I want for a while.
Yeah, so,
This is not got much.
well, I think it can end up going regardless. I think it'll end up going on to the Springs. This is very true. As far as experience, Judge Edwards is the chief judge of the DCA. Judge Lambert's the former chief. Judge Jay was a circuit judge, and he was actually on the first DCA, very rare to switch from one DCA to another. Just told my pastor that he got one of those. Okay. Yeah, they don't mess around. Good morning. Experience, short
Court is now in session. The Honorable James A. Edwards, Chief Judge, presiding. All persons having business before this court draw near, give attention, you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please.
I'll tell Charlie next week when I see him, you're doing a good job with it.
It's just about, this is about your anniversary today, isn't it, around now?
It was the...
Couple of years, yeah.
Last week.
Last week. You're doing great.
Nice speech.
All right, good morning. Welcome to a session of oral argument. We have one case on the docket. I've been introduced already. I'm Jim Edwards. I'll be presiding. To my right is our eminent and esteemed judge from the Ocala area, Judge Lambert. And to my left is our esteemed Judge Harvey J. from the Jacksonville area. And the one case we have today is 23-2963. If you have noisemakers, please put them on silent because they will go off at exactly the wrong time. We typically have 5 minutes rebuttal set for the appellant. If you want anything else, just tell me and we will change that around for you. And the time on the clock is your total time. You don't get that and then 5 more minutes. Just to be clear, I don't want anybody to run out of time unexpectedly. So with that, you may proceed.
May it please the court. My name is Robert McLean. I represent the Marion County School Board in this matter. Your Honors, this court should reverse the trial court's final judgment in favor of State Farm on its 627.7405 Florida statute reimbursement claim. As we've set forth in our briefs, the Florida legislature has the power under the Florida Constitution to abrogate sovereign immunity. However, the statutes purporting to do so must be clear and unequivocal. Neither 627.7405, the reimbursement statute, nor any other provision of the Florida Motor Vehicle No-Foro Law.
Why is that, counsel? Why do they need to be clear and unequivocal?
Because of the long-standing, centuries-long standard of sovereign immunity, that the sovereign, in this case, the government entity, the Marion County School Board, can only be sued if the legislature clearly and unequivocally waives sovereign immunity to permit the suit.
And I believe my colleagues as well understand the concept, and it goes back to the common law.
Yes.
Explain to us how, if it is, that is captured in the Constitution.
The Constitution grants the legislature the ability to abrogate the common law that the sovereign can, in other words, not be done, can do no wrong. But the case law going back for decades from the Florida Supreme Court has stated that any waiver of sovereign immunity must be clear and unequivocal. There are no magic words. However, there can't be a waiver by implication. The waiver of...
There cannot be a waiver by implication.
There cannot be a waiver by implication. The case law on that is very clear.
So do you think that's what happened here?
I
mean, they amended the statute in 1997 to, in essence, put the public transportation as being a commercial motor vehicle. In other words, if this was Trinity Catholic School Bus, a private school in Marion County, if this was their school bus and you were representing Trinity Catholic and State Farm wanted to get reimbursement for PIP, you would lose, wouldn't you?
We would lose.
Okay,
Because
the school board, but because you as a public entity own it, even though it's the same bus, I mean, let's say it's the same big yellow bus riding around on 27th Avenue or something like that. But
well, actually, it's not because a public entity owns it. It's because it is a public school bus. A public school bus that provides transportation to public school students can be owned by a private entity as well as a public entity.
So with that private, if you guys leased or hired some company to lease the buses to you guys for the transportation of the kids, and the same scenario we have here happened to that leased vehicle, even though it was used by the Marion County, for the benefit of the Marion County school children.
Yes, whether sovereign immunity applies or not contractually to the contractual party who has...
That private entity would then have the sovereign immunity carry over, is that what you're saying?
That's an open question. I don't have...
That's my open question, what do you think?
I do not believe so, because they are private entities. And under that scenario, as the 4th District stated in the Broward County School Board case, that private entity very well might be subject to lawsuit by State Farm for reimbursement, since that private entity who is contracted to provide the public school transportation, that private entity could be subject to reimbursement. However, as the Broward County Court stated in a footnote, that matter is still open for interpretation, and they weren't deciding it. The issue in that case, as is the issue here, is whether a school board-owned vehicle that is involved in an accident, whether the school board can be sued for reimbursement under 627.7405 by a insurance company for reimbursement of PIP proceeds.
My question for you is this. When I read 627, 732, 3B, which defines motor vehicle,
Correct.
if all it did was say, other than public school buses and blah, blah, but then it goes on to say, which is owned by a municipality, transit authority, or a political subdivision of the state. Well, certainly, the school board, is that not considered a political subdivision of the state ultimately?
Well, if that provision of the statute, Your Honor, is defining those commercial vehicles that are not subject to the no-fault law. There is an exception for public school buses. And as the 1997 law came forward, and as we discussed in our brief, the legislature passed that law in order to provide occupants of public school buses the ability to recover PIP benefits when they're involved in a car crash.
Right, but the 4th DCA in its recent case said, well, in order to find a waiver of sovereign immunity, you have to assume that only school boards own vehicles. If you're talking here about the fact that it's a public school bus, the odds are it's either owned by a company that's got a lease or it's owned by the school board, right?
That is correct.
And they don't come in here and say, okay, well, a public school bus is not a commercial, or is a commercial vehicle. It's not a commercial vehicle, which is how the statute's written.
Yes,
So
correct.
it is a commercial vehicle.
It is a commercial vehicle.
And
yes.
it can either be owned by somebody other than a school board or a county, or it's owned by a school board or a county. If they wanted to then say, okay, you can't get there from here, they could have said it right there.
They could have, and that would have made it particularly clear, but by the same token, they didn't say you could sue the sovereign, in this case the school board, the owner of that public school bus.
But when you say explicitly, clearly, everything else, in your opinion, it would have to say, and sovereign immunity is waived.
It would have to say more than it does. As the 4th District Court said in the Broward County decision, there has to be an explicit waiver of sovereign immunity that provides that the government entity can be sued, such as in the Maggio decision, where the Florida Civil Rights Act in that case explicitly included within the definition of an employer who could be sued for discrimination was a government entity. No such definition exists within the Florida no-fault law.
So the magic word, I mean, under 768.28, the waiver of sovereign immunity and tort, I mean, they expressly say that with certain limitations about that.
Correct,
All right,
yes.
so we're past, that would be the easy way.
That would be the easy way.
But we don't have that. We're now in the magic word world that you don't have to, it has to be clear and unequivocal, but there's no magic words that can be used to make it clear and unequivocal. It's in the context of whatever clear and unequivocal means. So then it seems like the fourth DCA threw you the lifeline to say, you know, clear and unequivocal is when you actually mention the state entity as a party, a potential party, the state or its subdivisions, and that is the case law that the first DCA in other contexts have said, well, that makes it clear and unequivocal that the intent was the state and its subdivisions would have sovereign immunity. And your position, if I'm following the logical extension, is because you don't have those magic words, it's certainly a logical implication that they intended that you not get sovereign immunity, but that then violates the Spangler, you know, concerns or caveat that says you can't make that implication or that leap, even if it makes perfect sense to do that.
Yes, I mean,
That's your case, isn't it?
yes, the analogy that I draw is when you're looking at an insurance coverage provision. Is it a reasonable interpretation of the statute that there is a waiver of sovereign immunity? Yes. But there's also a reasonable interpretation that there was not a waiver of sovereign
That
immunity.
reasonable interpretation.
Well, that reasonable interpretation, as we argued in our brief, goes to the fact that the 1997 amendments to the no-fault law that contained the change in the definition of a commercial vehicle also stated that owners of school buses do not have to provide PIP benefits. So under that logic, if the legislature had intended to make owners of school buses, public entity owners of school buses, subject to lawsuit for reimbursement, why at the same time did they make them exempt from
Let me
the
ask
PIP
this.
requirement?
You know, maybe in the days of yore for us older guys and gals here that we used to read what the legislative history to try to figure out what somebody did, but it seems like our Florida Supreme Court has made it fairly clear that don't read that stuff. Read the statute. The statute says what the statute says. However they got there is immaterial to your analysis as judges and lawyers, et cetera. Just read the statute. So, yeah, I mean, it might cut both ways here as to what the legislative purpose was in 1997, but is that kind of the paradigm has shifted as to why we can consider that anymore?
Well, I would say that in most circumstances, you are correct. You don't look at the legislative history.
Write that down. In most circumstances, I'm correct.
Unless,
Rarely, not always, but
Not
most,
my
most of the
case.
time. Most of the time, I guess right.
unless the statute is ambiguous. And there is case law from the Florida Supreme Court that has not been overturned that states that if there's a question as to what is the meaning of the statute, it is reasonable to look at the legislative history. But as the 4th District Court said in the Broward County case, you don't have to get there, because if you have to look at the legislative history to determine whether or not the legislature intended to waive sovereign immunity, then the statute is not clear and unequivocal as to the waiver.
A waiver of sovereign immunity is the exception, not the rule. If you have to work at it to find out whether it is, then it probably isn't. And, you know, part of our job as a DCA is to read the tea leaves from the Florida Supreme Court as to if they had this, which they may actually have this case, since the 2nd and the 4th have kind of taken divergent views and certified. So how would they see a waiver of sovereign immunity, you know, with their construction of matters here?
Well, of course, since I represent the school board, I
think the
believe,
4th is a pretty good
I believe that they're going to find that there is no clear and unequivocal waiver of sovereign immunity.
There is no clear and unequivocal.
Yes, correct. And of course, my esteemed counsel from State Farm is going to tell you that there is.
She probably didn't like that when she got the decision from the fourth, right?
Yes, but she liked the decision from the second.
One of the attorneys, right?
Yes, correct. And at the time that this case came before the Marion County Court, the decision from the second, the Lee County School Board case, was the only DCA decision, so that was controlling precedent.
No, you all professionally handled it well. You both attorneys and the trial judge in that context.
Thank you, Your Honor. Going forward, I see I still have 6 minutes left. As stated,
Where does the clear and unequivocal standard come from? I know it's in American Home Assurance. I know it's in the town of Longboat Key. Does it come from a text? Does it come from the Constitution? Where does it come from?
it is not specific, to my understanding, it does not come specifically from the Constitution or from the text of the Constitution. It comes from case law that was developed by the Florida Supreme Court in the cases you talked about, as well as the unpronounceable Sweffringhouse case and the Spangler case.
So if I wanted to trace where this standard came from, Spangler would be the starting point, or did it emanate before Spangler?
It's my understanding that it started with Spangler. However, I can research that further and let you know.
I'm pleased to look at it because I'm fascinated by it, but as far as you know, it's not traced to anything in the Constitution.
No, it's not traced to anything in the Constitution. It just follows from the fact that the common law stated that you could not sue the sovereign.
And I get that, and I think that's undisputed. That the English common law and the doctrine of sovereign immunity is our law unless the legislature, by general law, allows a claim to go forward. And that provision is Article 10, Section 13 of the Constitution, which I'm sure you know well. So would that be the place where we were to find clear and unequivocal?
That's where you start, and then you look at the Supreme Court cases interpreting that.
Well, Spangler says, inasmuch as immunity of the state and its agencies is an aspect of sovereignty, the courts have consistently held that statutes purporting to waive the sovereign immunity must be clear and unequivocal. Of course, they don't cite to the cases that they're saying that they came from, but,
Yeah.
but they're the Supreme Court from 1958, so, you know.
Needs
that's what
it's so well settled it needs no citation, right?
That's what basically Spangler stated back in the 50s.
You're down to about 3.5 minutes. Do you want to save that?
Yes,
time,
Your Honor.
whatever
I will save the remainder of my comments for rebuttal and allow my esteemed counsel from State Farm to come forward.
Thank you.
There's the Magna Carta in there, look at that.
Good morning, Chief Judge, members of the court. I'm Joni Armstrong Coffey with the Ackerman Law Firm representing the Appalachia State Farm. We would respectfully submit that appellant, the school board, and the 4th District have reached erroneous conclusions for at least 2 primary reasons which are interrelated. The first is, though, obviously sovereign immunity can only be waived by clear and unequivocal language in a general law. It does not require formulaic language.
You agree with that standard, clear and unequivocal?
Yes, sir.
And that's categorical. I mean, if it's
Categorical. No dispute.
if it's not clear and unequivocal, then sovereign immunity has not been waived.
That's correct. However, what it doesn't say is that specific language has to be used. And I know that the 4th District and appellant have conceded that magic words are not required, but in effect, what the 4th District opinion says is that you must expressly state the government that is a proper party to suit, and that sovereign immunity has been waived as to that government. That has not been the case law.
Other
And-
than tracing all of this back to Spangler, is there some predecessor to Spangler saying clear and unequivocal?
There is the town of Longboat Key, which I believe you mentioned, which I believe goes back to the 70s.
Is after, right, because Spangler's in the 50s, I believe, and town of Longboat Key is in the 70s, and obviously American Home Insurance is in the 90s, I think.
Right. And interestingly, even in Longboat Key, going back to 1970, the court found an equitable relief against the problem of dual taxation, even though there was no express waiver. So the idea of clear and unequivocal, yet not requiring express, goes back a very long time. But even beyond that, it's important to note that the definitional change in the no-fault statute is express. It is not an inference. And it does something very important. It takes...
The Fourth DC didn't disagree with that, did they?
No, they did not
I
disagree.
mean, they're not saying we're rewriting the statute. We're saying it certainly seems like these type of vehicles are subject to the PIP reimbursement, but they're saying, yeah, but it doesn't say a party, it doesn't name a state or a state agency or et cetera as a party, and that's how they differentiated the Lee County School Board case.
Correct, and that's how they got to the near inference that it was only private owners of public school buses. And I think the issue derives from the fact that the no-fault statute is not structured like the Florida Civil Rights Act or the Workers' Comp case in Maggio and Bafulco.
Well, let me follow up on Spangler. I mean, I read the last that sentence about the clear and unequivocal. The next sentence is waiver in Spangler. Waiver will not be reached as a product of inference or implication. It certainly seemed when they amended the statute in 1997 that the inference would be that entities that own that have school buses will be subject to PIP reimbursement by a state farm, correct? That's why isn't that why they wrote the statute?
I don't think it's an inference. I think it is the clear statement that public school buses are commercial motor vehicles, and commercial motor vehicles pay reimbursement. Now, going back to the structure, the Fourth had a problem because owner is not defined, but under the no-fault statute, no owner is defined. The classification system in the no-fault statute is by the kind of vehicle you own. So when the legislature decided to modify a commercial motor vehicle definition to include public school buses, it took the public entities that own school buses out of tort liability. Here's the issue here. The school board concedes it's not responsible to its passengers in tort anymore, but it doesn't want to pay reimbursement either. It's using sovereign immunity as both the sword and the shield.
Why is the school board not responsible in tort?
Because its passengers, its private passengers who are injured, are now reimbursed by their private carriers.
But I mean, there's still, I mean, if I'm a bus driver and I negligently drive and I injure a bunch of the kids in the bus.
They're subject to no-fault recovery.
Yeah, but the school board's still liable for the negligence of their
But if
driver.
I run into your school bus,
No,
No,
sir.
but I get it if you're not at fault. If it's no fault, which is why we're here.
No, sir, no fault. The no-fault statute takes, let's just for a moment assume that it is a city bus, just to take the school board entity out of it. It's a city bus, and there is well, no, let's not. Let's go back to the school board. If their private passengers are injured, the private passengers' own carriers now pay. And under State Farm's reading of the statute in peri materia, in context, the school board is not liable, even if they're negligent, to those passengers anymore.
So-
However, they're liable for reimbursement. That's the way no fault works for commercial motor vehicles.
To follow up on Judge Lambert's very good question, does 76828 play a part in any of this?
No, sir, because the school bus is now out of tort liability in the, that's why you have to read all the parts of the no-fault law in peri materia. It takes school buses and their passengers out of tort liability, just like any PIP no-fault case. It doesn't have to do with fault. It has to do with the no-fault coverage.
Maybe we're diverging a bit, but I do want to. So here, the school board, the bus driver was not at fault in this case, and that's why we're in no-fault land.
Respectfully, Judge, it doesn't matter.
Well, I guess I'm not, so if I'm driving a school bus and I'm going 142 miles running through stop signs and I hit a telephone pole and I injure the kids in the bus, you're saying the school board cannot be sued?
You're
I mean,
covered-
assuming it's not reckless, you know, that takes it under the 768.289A.
No, sir, because
I'm-
they have,
I think they're going to be very happy walking out of here regardless of how that happens, if that's what the law is. Saying you can do whatever you want, we can never be sued and tort.
it's the essence of no-fault coverage. You are taken out of tort liability. Now, let me be very
I
clear.
get all that. You're talking to an old insurance defense attorney.
Let me
I
be-
get all that, but I don't understand the premise you're saying that
Let me-
there's. Go
I
ahead.
don't either.
I have no idea how they had no tort liability.
Let me be very clear that there is a level of liability beyond the basic injuries, which are life-altering injuries, which goes beyond the PIP benefits. But the truth is, the school board, by redefinition, starts behaving like any commercial motor vehicle. Its passengers are paid by their private carriers, and then the commercial carrier reimburses the private carriers.
Assuming they have, okay. We're getting off topic, and perhaps it's my fault. I get no fault. I mean, that's why we're here. You guys pay regardless of fault, and now you want to get the no-fault benefits from them. But the blanket comment that there's no tort liability for a school bus driver who negligently injures their students, the students in the bus, I'm...
You're saying there's no liability, or it just doesn't matter?
If you read 627 point, and I think it's 733, there is an exemption from tort liability for insureds who are covered, not insureds, for motor vehicle operators who are subject to the no-fault law. It is an express exemption. That's why the whole statute has to be read together, and I should walk over and get the statute.
I don't know that it's neither here nor there. I don't think you're right, but as McLean says, you know, sometimes I'm rarely right or occasionally right or something. So.
Let me just...
Let's talk about this case. Forget about that for a second.
Okay, let's just return to the basic issue, which is the legislature could have done this a very different way. Instead of redefining commercial motor vehicles for purposes of this entire statute, including reimbursement, they could have simply had a one-clause section that said private carriers will reimburse the passengers in a school bus, and left it at that. That's not a waiver of sovereign immunity. But they didn't do that. They expressly redefined commercial motor vehicles for purposes of, they didn't say for subparts of the statute. In fact, they had to make an express exception from the section that otherwise would have required school boards to carry insurance. The whole idea is that school boards are now not subject, and we'll go back to that issue, to 768.28 for these purposes, but they are subject to no fault. The whole idea is they're treated like any other commercial carrier.
Right, and that takes me back again in my mind to where's the explicit statement that sovereign immunity is waived?
Well, if we could go back to Town of Longboat Key, there is nothing in Supreme Court precedent that says that there have to be words that say, we hereby expressly waive sovereign immunity, or the legislature hereby waives sovereign immunity, as in 768.28. There is nothing in the precedent except the 4th DCH opinion in Broward County that says that. You have cases in which you found a remedy for dual taxation. You have, as my opposing counsel mentioned, the Schweifringhaus case, in which the Florida Department of Transportation was found liable for an indemnification clause, even though there was no express statutory waiver of sovereign immunity, simply because the legislature in its statute had authorized FDOT to enter into a contract, and indemnification was one of the provisions in its contract. So it has never been the law that there have to be magic words. And if you split up the no-fault statute, we believe, as was done in
You say there has never been a case saying there have to be magic words, but we do know, based on both sides have conceded, it has to be clear and unequivocal. That could be magic words, words of clarity, and words that are not equivocal. You would agree with that, would you not?
Yes, sir.
So where are the clear and unequivocal words here in our case?
The clear and unequivocal words are the express redefinition of school buses owned by a public entity, of public school transportation.
Saying this public entity can be sued?
Unequivocal is not the same word as express. I would say that...
So differentiate those. I'm curious.
Well, clear and unequivocal means, look, the case law from this court and all the other courts in Florida say what the legislature said is the poll star. And so we have a redefinition that has to mean something. It means this is a commercial motor vehicle for purposes of the statute. That's an express provision, but it is not a formulaic language of, as in 768-28, sovereign immunity is hereby waived. That is one system. That's one way to do it. The Maggio and Bafulco cases, which prior to the fourth DCA we cited, the Florida Supreme Court said, okay, it's in a definition. So therefore, that is clear and unequivocal, even though...
And thanks for pointing out 768-28, because it does expressly say in that statutory section that sovereign immunity is waived to the extent that, correct?
It does.
It's not here.
No, it is not here, nor was it in Maggio and Bafulco. In Maggio and Bafulco, the two statutes at issue, the Florida Civil Rights Act and the Workers' Comp case, said they defined employer and person. And in those definitions, there was only a definition of government as an employer person. It never said, like 768-28, sovereign immunity is hereby waived. Never said that. But the Florida Supreme Court said that's clear and unequivocal because there's an express definition. We have an express definition here. We don't have sovereign immunity is hereby waived.
Yeah, it's kind of the same. The earlier discussion I had with your opposing counsel is, we sit here, especially if there's a conflict, so we're obviously going to be on, well, we shouldn't say obviously, that'd be an inference, no pun intended. The DCAs are lining up one way or another on this, and the Supreme Court hopefully will take the conflict and accept it. So, when we're trying to analyze which side of the fence we're on this case, we fairly should think about what is the Supreme Court, how will they look at this? Do you agree? Wouldn't that be a fair thing? I mean, we shouldn't say, well, we think we're going to go this way even though we know we're going to get reversed. I mean, we shouldn't do that, and I don't think any of us do that. But I mean, so I'm trying to think that the Supreme Court is going to look at this and say, well, there's nothing express. Sovereign immunity is the exception, is the rule, not the exception. There's first DCA case and the fourth DCA saying, if you really want to be unequivocal about this, you should define the state or its subdivisions in the statute, and that makes, then there's the link. It's not expressed, but it's clear and unequivocal that the intent of the statute is to have a state agency or an entity be here. That seems like the direction that the Supreme Court, the makeup of the current Supreme Court, would be looking at this. Does it not? I mean, I know that you should probably say no because that's contrary to what you want to have happen.
Well, I think there's
but
another way.
I'm struggling to say how they're going to look at it this way.
I think that there's another way that the court might look at it, which
Well,
is
the plain language says this, and therefore the plain language is the plain language, and we love plain language.
I think the court could say, asking more than clear and unequivocal through an express definition like we have here is imposing a new judicial rule on the legislature. It's got to draft in a specific way, or their effort to waive sovereign immunity won't be.
Well, haven't they done that in Spangler, saying it has to be clear and unequivocal for there to be a waiver? And I mean, that's judicially created by them in Tallahassee.
Clear and unequivocal was in American Home Assurance, was in Town of Longboat Key, was in the FDOT case. clear and unequivocal is not the same as the rule, Judge, that you said, which is you've got to define government in the definitional section of the statute.
Why isn't it the fourth DCA being appropriately cautious, saying, you know, this seems like it should be a waiver, but you know what, that's for the legislature to make a little clearer here, which they can. We're not going to rewrite the statute. The statute says what it says. These type of vehicles qualify, and it's a logical inference that the public entity school board owns these things, but we're going to defer to the legislature to actually make that unequivocal. We're not telling them how to write it. We're just not sure it's unequivocal, and when we're dealing with public money, we shouldn't step into the shoes of the legislature and or the governor about this. How does that not right in the wheelhouse of the Supreme Court right now?
I think that the Fourth's position was more of an inference. That way of looking at it takes the court to the inference that somehow the legislature intended that only private owners of public school buses were covered by reimbursement.
We think we know what their inference is, but we can't take that judicial leap, because that's not us. We have to recognize separation of powers, and the sovereign immunity is construed favorably towards the subdivisions of the state. That seems kind of thematic up there.
If I were to stress anything, it is the distinction between a clear and unequivocal knowledge of what the legislature did, and the second DCA, in our view, obviously got it right. It said a commercial motor vehicle includes a school bus, public school bus. Commercial motor vehicles pay reimbursement. All the rest of it is a lot of inferences, a lot of magic words, a lot of failure to read the statute as a whole. And I think that it is actually a worse place to be than, well, the Fourth is a worse place to be than the second, because the second took the simple and straightforward interpretation of the statute. And for that reason, we would respectfully request that you affirm, that you adhere to, or that you agree with the Second District Court of Appeal and affirm the summary judgment below. Thank you, Your Honors.
Yeah, thank you.
Your Honor,
you guys can't be sued if your bus driver is negligently driving and hurts their passengers?
we can be sued. Sovereign immunity has been waived by 768.28 if the, in your scenario, if the parents of the minor child who are injured in the accident as a result of the
I can remember the
negligence.
school board bus driver left the kindergarten student off at the wrong bus stop the first day of school, and she got struck by a passing car, and that family sued the school board and
So long as
collected.
So long as the plaintiff follows the pre-suit
Provides the
notice
notice and all
requirements
that
of the
stuff, yeah.
statute, then yes, they can. I think what counsel was talking about is the $10,000 that are provided under PIP.
I get what you, let's
Yeah.
talk about this. I mean, I was just, that kind of threw me for a loop there, because
Yep.
I can remember cases like that for reasons, so we'll just keep where we are.
And I, as a plaintiff's lawyer, have pursued those types of cases.
All right.
But
So why isn't the statute clear and unequivocal? I mean, who else are we talking about but school boards when they amended the statute?
well, what the statute is talking about, it makes an exception to an exception, where it says that mass transportation is not a commercial vehicle except if it's a public school bus. But it does not go on to say that, yeah, you can sue the owner of the public school bus if it is a governmental entity for reimbursement. It doesn't say that explicitly, nor does it say it clearly and unequivocally. There's a reasonable inference that it
A half inch
does.
up on the page, it talks about the fact that the vehicles, whether it's the school bus or not the school bus, it talks about being owned by governmental entities.
Yes.
It's
It-
not like, I mean, so when you talk about owner in the next breath, or skip one breath and then the next breath, How can that not mean to include a governmental entity?
Because that is talking about those vehicles that
City buses and
are
trains
not
and all that.
commercial vehicles.
I get that, but I mean, the thought is there. It's not like they don't think about, don't express the fact that they understand vehicles can be owned by the government.
Yes.
And then when they go down, here's who the owner is, and you go back to 627-74051, and it says, you know, they have a right of reimbursement against the owner. Would they have to say including a governmental entity?
Private or public. There has to be more than an implication, and even if it's a reasonable implication, which is in 627, the statute defining commercial vehicle or motor vehicle. That may be a reasonable interpretation of the statute, but just a reasonable interpretation is not enough. You can't get there by implication, and there is no clear and unequivocal waiver.
Unless there's other questions, please wrap up.
I see the red light is on.
You're correct. Okay, thank you very much.
Thank you, Your Honor.
Thank you.
Very interesting case. Yeah. Thank you. We'll be in recess.
Good to do these in person.